facts of the case is that Your
Who is appearing for the other side?
Your Lordship, I'm appearing for the other side. Your Lordship, if
Who?
I may be granted at least a daytime to go through the petition so as to be, so as to check whether it's a covered matter or not.
Okay, let her take instructions.
Then, in that case, if Your Lordship may kindly fix it in the week commencing 23rd.
Okay.
I have some personal.
Okay. Heard Mr. A.R. Malhotra, learned counsel for the petitioner. Also heard Miss Zairin Santi, learned Central Government Council, appearing for respondent number 1 and 2.
Yes, Your Lordship.
1 and 2. And Miss Mary L. Chiante, appearing
Your Lordship, 1, 2, and 3.
1, 2 and 3. And Miss Mary L. Chiante, learned counsel, appearing for
What to
learned
say.
government counsel, appearing for the other respondents. This application under Article 226 of the Constitution of India has been preferred by the petitioners, praying for issuance of writ in the nature of mandamus / or any other appropriate writ or direction, alleging that though the land of the petitioners have been acquired, same has been done under Mizoram Land Acquisition, Rehabilitation and Resettlement Act 2016, instead of right to fair compensation and transparency in Land Acquisition, Rehabilitation, Resettlement Act 2013. Learned counsel for the petitioner has submitted that this matter is covered under earlier judgments passed by this court. In which case? In WPC?
Your Lordship, WP 83 of 23.
WPC number
83 of 23.
83 of 23
And 37 of 25.
and WPC number 37 of 25, wherein under similar circumstances the court has directed to apply the provisions of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. Stop. He submits that this writ petition may be disposed of in terms of the judgment passed in the aforesaid writ petitions. On this, Ms. Marian Chiante, learned government counsel, appearing for the state respondent, seeks how much time?
2 weeks.
Seeks 2 weeks time to take necessary instructions in this regard, and if necessary to file an affidavit in opposition. The prayer is allowed. Stop. Issue notice. Stop. Since all the respondents are represented by their engaged counsels, no formal notice need to be issued. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Knowledge.
For admission, item 3.
Lordship, I am appearing on behalf of the state respondents 1, 2, 4, and 5, and I've already filed my affidavit.
Lordship, in this matter, the Central hasn't filed their affidavit.
Yes. Who has filed it? Union of India has filed its.
Manada, for respondent number 6, I may be given 2 weeks time for filing my affidavit.
Last occasion also you sought 2 weeks time.
My Lord, I'm appearing for respondent number 2, and we'll be filing our affidavit and vakala number today.
Affidavit also today? Okay. Heard, Miss, what is
Lel Rinami Chakchwa.
Learned Counsel for Lal Rin Wami Chakchuak, Learned Counsel for the petitioner. Also heard Miss Zairim Sangpui, Learned Counsel for respondent number 6. No, also heard Mr. Samuel Van Lal Shiata, Learned additionally appearing for the state respondents. Standing counsel NHIDCL appearing for respondent number 7 to 9. And Miss Caroline, you are appearing for state respondent.
Yes, my lord.
Appearing for respondent number 1, 2, 4, 5 and 10. Also at Ms. Zarem Sangpui, Learned Central Government Council, appearing for respondent number 6, who seeks 2 more weeks, who seeks time for 2 more weeks for filing affidavit in opposition. The prayer is allowed. Mr. What is your name?
Lopsa.
Lopsa. Write his name. Appears on behalf of respondent number 3 and submits that he will be filing his power as well as affidavit in opposition during the course of the day. Stop. Let this matter be listed after 2 weeks.
Item 4.
May I please?
Yes.
The petitioners are aggrieved with the action of the respondents, state respondents, as well as the Mizoram Public Service Commission in recommending the private respondents number 6 to 17 for appointment to the post of surveyor as per Annexure 10, page 110. The English translation is available at page 113 here.
Just a minute. Yes, what is there in 100? What is 110?
The recommendation at page 113, if I may be allowed to read here.
Yes.
The Mizoram Public Service Commission conducted written technical competitive examination between 21st and 22nd November 2024, and personal interview between 28th to 30th July 2025, and the below noted are recommended for appointment under Land Revenue and Settlement Department as surveyor. So, Your Worship, we agree with the recommendation by the MPSC, Public Service Commission, in favor of the respondent.
These are permanent posts.
These are government posts.
Okay.
So we are challenging the recommendation as being in violation of the recruitment rules. And the private respondents who have been recommended, their names appear at serial number 1 to 8. 1, 2, 3, 4, 5, 6, 7, 8, 10, 11, 13 and 14. The private respondents appear at serial number 1, 2, 3, 4, 5, 6, 10, 11, 13 and 14.
Yes.
Now, if I may take your lordship to the relevant recruitment rules, which is at page 21.
Yes.
Your Worship, if I may be allowed to read.
Yes.
In exercise of the powers conferred by the proviso to Article 309 of the Constitution and in supersession of the Mizoram Land Revenue and Settlement Department Group B Post Recruitment Rules 2009, notified in the Mizoram Gazette dated 20th of August 2009, except as respect things done or omitted to be done before such suppression, the Governor of Mizoram hereby makes the following rules regulating the method of recruitment to the posts of Surveyor 1 and Surveyor under Land Revenue and Settlement Department, Government of Mizoram. We are concerned with recruitment to the post of Surveyor, Your Lordship.
Yes.
Now, if I may take Your Lordship to page 23. This is the schedule. Altogether, there are 13 columns. Page 23 and 24, Your Lordship will see, altogether there are 13 columns. And as Your Lordship got the
13.
13 columns.
Only 10 columns are.
Page 24, the next page, Your Lordship. 11, 12 and 13. They are altogether 13 columns.
Okay.
13 column is circumstances in which MPSC is to be consulted.
Yes.
Altogether, there are 13 columns.
Yes.
And page 23, Your Lordship will see the post of surveyor.
Second row.
Yes, second line here. The number of posts is at column number 2. Column number 3 is classification. Column 4 is level in the pay matrix. Column 5 is whether selection or non-selection posts. And column 6 is age limit for direct recruitment. Column 7 is educational qualification and other qualification required for direct recruitment. So regarding this, the qualification required for the surveyor, post of surveyor is at page 24.
Yes.
So the qualification required for the post of surveyor, number 1, basic bachelor's degree from a recognized university who have completed at least 1 year survey course from any government recognized institution. That is number 1. Number 2 is basic knowledge of computer application equivalent to course on computer concepts of National Institute of Electronics and Information Technology or diploma in computer application / certificate in computer application from institutions recognized by Mizoram State Council of Technical Education or such other courses of the level as determined by government from time to time. Number 3, working knowledge of Mizo language, at least middle school standard. So these are the educational qualifications required for appointment to the post of surveyor under the Land Revenue and Settlement Department. So now the basic thrust of the argument of the petitioners is that the private respondents have not qualified the requirement given under number 1, bachelor's degree from a recognized university who have completed at least 1 year survey course from any government recognized institution. So the essential qualification, Your Lordship, is twofold. One is a bachelor's degree from a recognized university. Second is 1 year survey course, at least 1 year survey course from any government recognized institution. So 2 things are required under this, a bachelor's degree and a survey course of at least 1 year. Bachelor's degree from a recognized university who have completed at least 1 year survey course from any government recognized institution. So my submission, Your Lordship, is that apart from a bachelor's degree, you need a survey course of at least 1 year from a recognized government institution. 2 things are required. And the case of the petitioners is that private respondents, they are graduates in engineering. They do not have a survey course of at least 1 year from any recognized government institution. In spite of that, they were allowed to take part in the examination and they have been recommended for appointment to the post. So my humble submission, Your Lordship, is that they do not fulfill the required essential qualification as per the recruitment rules, which says that number 1, a bachelor's degree from any recognized university. Number 2, survey course from any government institution of at least 1 year. The private respondents, Your Lordship, are all graduates in civil engineering. They do not have that additional qualification required, that is survey course of at least 1 year from a government recognized institution. So my humble submission, Your Lordship, is that since they did not fulfill the requirements of the recruitment rules, they could not have been allowed to participate in the selection process. But in spite of this, they have been allowed to take part in the selection process and they have even been recommended. So that is where the dispute lies. And it is an admitted fact by the state respondents as well as the private respondents that they do not have this 1 year survey course, at least 1 year survey course from any government recognized institution.
Whether they have been appointed?
No, Your Lordship. There's a stay granted by this Honorable Court. The appointment orders have not been issued.
Is there any relaxation clause in the rules?
Yes, but that has not been invoked.
Where is that clause?
Page 22, Rule 8.
Rule?
Rule 8, page 22. Power to relax.
Please read.
Where the state government is of the opinion that it is necessary or expedient to do so, it may by order and for reasons to be recorded in writing, in consultation with the DPNAR, relax any of the provisions of these rules with respect to any class or category of persons.
When this may be invoked?
Your Lordship, according to my understanding, where the state government is of the opinion, so when the government feels that it is necessary to relax the provisions of this rule.
No, whether can they invoke it now?
At this stage, Your Lordship, I mean, like at this belated stage, how can they do that?
No, that is my query. Can they do so?
I don't think at this stage. They have already notice, the advertisement has already been issued, all the applications have already been filed, examination conducted by the MPSC, recommendation already made. At this belated stage, how can
Okay.
And it is not the case of the state government that they have invoked this clause.
Relaxation clause. Okay.
It is not their case. Judge, with regard to this, I'd like to rely on the judgment of the Supreme Court in 2025 SCC Online 711. SCC Online 711.
Yes.
Judge, if I may read this may take some time, but if your lordship will kindly bear with me, this judgment will, I think, be applicable to the facts of our case.
Yes.
This is Jongjon KK versus Shajimon P and others. I'll read from para 2.
Yes.
Facts giving rise to these appeals which are not in dispute are these. An advertisement dated 17 October 2012 was published by the Secretary of Kerala Public Service Commission inviting applications from interested candidates for filling up 12 vacant posts of board Laskar under the Kerala State Water Transport Department. The method of appointment was indicated as direct recruitment and qualifications stipulated therein read as follows. Qualifications: number 1, literacy in Malayalam or Tamil or Kannada. Number 2, possession of current Laskar's license. Note: candidates should possess current Laskar's license on last date of receipt of publication, during practical tests and interview also. So, Your Worship, in this case, the appellant was not having the license of a Laskar. He was having a higher license, which is that of a Sairam. Regarding this, I'll carry on clause B. Incidentally, if I may read it.
Yes, yes.
Incidentally, in terms of the special rules of 1975 for the Kerala State Water Transport Subordinate Service Operating Wing, the service would consist of 3 classes of officers, while Class 1 comprised 2 categories. Classes 2 and 3 comprised 3 categories. This Category 1, Category 2 and Category 3. Sairam, Driver and Laskar are listed as Categories 1, 2 and 3 respectively of Class 3. In terms of the schedule appended to the special rules, the post of Sairam can be filled up either by direct recruitment or by promotion from among Laskars in the ratio of 1:1, whereas appointment on the post of Laskar is entirely by direct recruitment. It is also provided in the schedule that while literacy in Malayalam or Tamil or Kannada is the common qualification required for appointment as Sairam as well as Laskar, an individual aspiring for the post of Sairam must possess current Sairam's license, while an individual aspiring for appointment on the post of Laskar is similarly required to possess a current Laskar's license.
Yes.
So Your Worship, as per the advertisement, for the post of Laskar, what is required is a license of Laskar. In this case, the applicant was holding the license of a Sairam, which is above the license of Laskar. D, if your Lordship will see, I'll carry on with D. By a letter dated 9th October 2012, addressed to the Director of the Department, the Director of Ports conveyed to the following effect. This is to communicate formally that the Sairam Master and Driver License certificate issued by the Chief Examination under the KIV Rules 2010 is a certificate superior to Laskar certificate. Hence, those who possess Sairam Master and Driver certificate will be proficient in Laskar work also. Thus, Sairam and Master certificate can be considered more than equivalent to Laskar certificate, and such persons are eligible for the job of Laskar. This communication is issued based on the representation received from a few candidates who applied to the Public Service Commission for Laskar job in order to enable them to complete the application process. Copy of the representation is enclosed. However, the final selection may be done based on practical tests on the skills required, type of vessel, and other requirements of the organization. The applicant was the holder of a Sairang license, which was valid when he noticed the advertisement. Perceiving that possession of a Sairang license makes him eligible to apply for the post of Laskar, which incidentally happens to be the feeder post for promotion to the post of Sairang. The applicant offered his candidature and acquitted himself creditably, resulting in his name figuring at serial number 1, OX category in the ranked list, which was circulated by number so-and-so and brought into force with effect from 22nd February 2017. He had secured 45.67 marks. Based on such rank, the Secretary KPSC informed the applicant by letter dated 2nd May 2017 as follows. You are informed that you have been advised for recruitment as board Laskar on rupees so-and-so in the above department against BC Third. The selection is subject to Rule 3C and 10B of the Kerala State and Subordinate Service Rules 1958. Further instructions will be issued to you in due course by the above department. While the applicant was awaiting an offer of appointment on 8 May 2017 and 27 July 2017, two sets of original applications under Section 19 of the Administrative Tribunals Act 1985 were filed before the Thiruvanthapuram and Ernakulam benches of the Kerala Administrative Tribunal. The prayer in OA 857 of 2017 was for a declaration that inclusion of ineligible candidates who do not possess the essential qualification is oppressive, arbitrary and illegal. A direction be issued to restructure the ranked list by removing all such ineligible candidates and to pass incidental orders. In OA 1566 of 2017, similarly, the tribunal was urged to declare candidates who do not have valid and current Laskar's license as on 17 October 2012, that is the last date for receipt of applications, as not eligible to be included in the rank list, as well as for issuance of a direction to KPSC to recast the rank list by excluding the candidates not possessing valid Laskar's license on 17 October 2012. Importantly, in OA number 857 of 2017, no private party figured in the area of respondents, and there were only 3 official respondents: Director of the Department, Director and KPSC. In OM number 1566 of 2017, apart from official respondents, only 5 of several selected candidates were joined as respondents. The applicant was not one among the 5 private respondents who were included in the said application. During the pendency of the original applications before the tribunal, the applicant came to be appointed on 28 July 2017 as board Laskar. The reply statement filed by the director before the tribunal on 20th February 2018 is extracted hereunder. Port Department is implementing KIV rules 2010. Director of Ports is the competent authority to oversee the various regulations under the provisions of the KIV rules 2010. KIV insists that the master, driver and Sairang certificates will be issued only after 2 years from the date of issue of Laskar certificate by the Chief Examiner, Department of Ports. So the persons who got competency certificates for master, driver and Sairang also have sufficient eligibilities to be the board Laskar. The above competency certificate holders are also eligible to apply for the post of Laskar, and it is stated by the Director of Ports in the letter number so-and-so dated 9/10/2012. In due course, the original applications were heard by the tribunal. By the judgment order dated 9 March 2018, the tribunal allowed both the original applications and directed KPSC to recast the ranked list and to cancel the advice to appoint ineligible candidates. Acting in pursuance of the tribunal's order, KPSC issued a show cause notice dated 31/7/2018 to the applicant, calling upon him to explain why the advice for his appointment be not treated as cancelled. The applicant responded thereto by his reply dated 10th August 2018. Thereafter, KPSC issued an order dated 24th October 2018, cancelling the advice for appointment of the applicant following which the director cancelled the appellant's appointment as Board Lasker by his order dated 27 October 2018. On 3rd November 2018, the appellant challenged the tribunal's order before the High Court in separate writ petitions. However, Division Bench of the High Court, by the common impugned judgment and order, dismissed such writ petitions. Contentions of the parties. Mr. P. N. Ravindran, learned senior counsel for the appellant, argued that both the tribunal in allowing the original applications as well as the High Court in dismissing the writ petitions fell in error in not appreciating that a higher qualification could never have been regarded as a disqualification for appointment on the post of Lasker. So I'll take your lordship to the para 12, question of law.
Yes.
Para 12. The central question of law arising for decision on this appeal is whether the appellant, who did not hold a current Lasker's license but was the holder of a Siran license, could have been considered qualified to participate in the recruitment process as well as appointed. Certain notable features having a bearing on the issue to be decided by us are these. The advertisement dated 15 September 2012 did stipulate that only those holding a current Lasker's license are eligible to apply. At the same time, it did not specifically say that anyone holding a Siran license or a license higher than a Lasker license is not eligible to apply. According to director, a Siran license is something superior to a Lasker license, and that holders of Siran license can be considered more than equivalent to Lasker's license, thus being eligible for the job of Lasker also. A communication to the above effect was made by the director to KPSC, not on his own but based on the representation received from a few candidates who, presumably having Siran's license, had applied for the post of Lasker and wanted to compete with aspirants having Lasker's license. Despite the appellant being selected, his name figuring in the rank list, he being recommended by the Secretary KPSC on 2nd May 2017 for appointment as Board Lasker, as well as his appointment on 28 July 2017. During the pendency of the original application, he was not impleaded as a respondent therein. So this is regarding non-impleadment of the appellant hearing. I'll take your lordship to the analysis and reasons.
Yes.
Para 20 onwards. I'll read from para 20 onwards.
Yes.
Next, turning to the crux of the issue, it is absolutely necessary to bear in mind that though the posts of Siran and Lasker are included in Class 3 of the subordinate service, the requisite qualifications for appointment on such posts as ordained by the special rules are different. Moreover, it is specifically ordained by Rule 6 of the special rules as follows. Other qualifications. No person shall be eligible for appointment to the category specified in column 1 of the table below by the method specified in column 2, unless he possesses the qualifications prescribed in the corresponding entry in column 3. As noted in the factual narrative, possession of a current Lasker's license is an essential qualification for anyone aspiring for the post of Lasker. This is what is laid down in column 3, that is, qualifications required. And going by what is said therein, read with Rule 6, there can be no gainsaying that apart from those having a current Lasker's license, none else is eligible. The word current is also significant in the sense that the rules insist on a subsisting license, that is a certificate of competency, which is valid and operative during the time the last date for receiving applications intervenes. The advertisement did not require anything else other than what the special rules require. The absence of express mention that those holding a Siran's license or a driver's license, which according to the director are superior to a Lasker's license, is insignificant, irrelevant and immaterial, having regard to the clear terms of Rule 6. If viewed from a different angle, on a conjoint reading of Rule 6 of the special rules and the advertisement, we find both mentioning a particular qualification, that is a current Lasker's license, which each aspirant has to possess for being considered eligible to participate in the process of selection, thereby creating a distinct class, and it is aspirants falling in such class alone who could have applied for being considered. Thus, any aspirant, even though possessing a siren's license or a driver's license, not being of such distinct class, could not have been considered eligible. The classification has not been shown to be and is not unreasonable. True, it is from the reply statement of the director filed before the tribunal and also from the 2010 rules, it does appear that the holder of a siren license is mandatorily required to obtain and have a LASCA's license for 2 years, and therefore, without having a LASCA's license, one cannot apply for a siren license. By the same analogy, it could be presumed that the holder of a siren license is having the requisite eligibility to be a LASCA. However, what turns the tide against the appellant is the requirement of current LASCA's license discussed above, which the appellant did not have on the last date for receiving applications. We have further seen from the letter of the director dated 9 October 2010 addressed to KPSC that it was not voluntary. Rather, it was at the behest of the candidates who did not possess current LASCA's license. It can well be presumed that the director buckled under pressure. However, notwithstanding that qualifications statutory laid down could not have been diluted by what the director felt should be considered by KPSC, and therefore it is the statutorily prescribed qualifications that should prevail. I'd like to lay stress on that, Your Worship. It is the statutorily prescribed qualifications that should prevail. Mr. Nair is also right in referring to the decision in M. Tripura Sundari Devi. Although in such decision, it was held that it amounts to a fraud on public to appoint candidates with qualifications inferior to the qualifications advertised, which is not precisely the case here because the appellant has higher qualifications than what was required. Yet the other principle of law flowing from such decision is clearly applicable. It has neither been shown that the director's letter dated 9th October 2012 was given wide publicity, nor has it been shown by the appellant that KPSC had issued any corrigendum wide public notice whereby the zone of consideration was enlarged, permitting holders of a siren license to participate in the process. We thus hold, drawing inspiration from the said decision, that the aggrieved are all those who had similar or even better qualifications than the appellant, who had not applied for the post because they were unaware of the fact that persons not having a current LASCA's license would also be eligible to apply and complete in the process. Equality of opportunity in matters of public employment being a sign for a fair and transparent selection process, such equality is conspicuously absent in the present case. With regard to this para 26, I'd like to take your worship to the affidavit filed by the state. Respondents 1 to 3.
Yes.
Worship, in this, Annexure 60, Your Worship,
Page.
page 75.
Yes, what is this?
Your Worship, this clarification was asked by the Public Service Commission. Respondent number 4 and 5, Public Service Commission had asked for a clarification from the government. And the government had given
Before
this
declaring the result.
before declaring the result, but after the applications were submitted.
Okay.
If your Lordship will allow me to just, regarding that,
Yes.
advertisement was issued on 9th July 2024. Annexure 3 of the writ petition.
Okay.
The the advertisement was issued on 9th July 2024. Applications was allowed to be submitted till 9th of August 2024.
And what is this at page 75?
Page 75, Your Lordship, this is the letter dated 6th of September 2024. In the clarification which was asked for by the Public Service Commission, reference number, this letter is dated 19th of September 2024.
Yes.
So that means, Your Lordship, this letter from the Public Service Commission was written to the government on 19th of September 2024 after the last date for submission of applications, which was 9th of August 2024. The advertisement clearly says that the last date is 9th of August 2024. So after the last date of applications, the Public Service Commission asked for a clarification from the state government, and this is the reply of the state government with reference to the letter number and the subject mentioned above. I am directed to inform you, government and DPNR GSW has considered the qualification of BE Civil as acceptable for direct recruitment to the post of surveyor, provided that a 1-year surveyor course is included as one of the subjects. Meaning, it has to be one of the subjects in the BE Civil course, Bachelor of Engineering course.
Okay.
This was not published by the Public Service Commission or the government to give all those graduates in BE Civil a chance to apply for the post of surveyor. This is what has been held in para 26 of the judgment, which I have just been reading. If I may read para 26 again.
Who are you?
I am a graduate who has done the survey course of at least 1 year. I am qualified as per the recruitment course.
You applied for the post.
We applied for the post, we took part in the selection process, but when the results came out, those who did not have that survey course and who only graduates in civil engineering were recommended. Now in the affidavit filed by the state, they have annexed this letter, Your Lordship, which shows that there was some clarification asked by the MPSC, and they have clarified that those holding the qualification of BE Civil can be accepted for direct recruitment, provided that 1-year survey course is included as one of the subjects. This is against the rules. The rules does not say this. Plus, this clarification was not issued in the public domain, so that all those holding the qualification of BE Civil and that survey course of 1 year is included in the subject could have also applied for the post. That, Your Worship, the Supreme Court has held that is in violation of Article 16. If I may read para 26 again.
Yes.
Now, Your Worship, if I may read para 26. Before reading para 26, Your Worship, para 8 has to be read together with 26. Para 8 and 26. If I may read para 8 first.
Yes. Yes.
Mr. Nair, if I may,
Yes.
para 8. Mr. Nair relied on the decision in District Collector and Chairman Vizianagaram Social Welfare Residential School Society and M. Tripura Sundari Devi for the proposition that when an advertisement mentions a particular qualification and an appointment is made in disregard of the same, it is not a matter only between the appointing authority and the appointee concerned, The aggrieved are all those who had similar or even better qualifications than the appointee or appointees, but who had not applied for the post because they did not possess the qualifications mentioned in the advertisement. Now I take your attention to para 26.
Yes.
Mr. Nair, para 26, Mr. Nair is also right in referring to us the decision in M. Tripura Sundari Devi, Supra. Although in such decision it was held that it amounts to a fraud on public to appoint candidates with qualifications inferior to the qualification advertised, which is not precisely the case here, because the applicant has higher qualifications than what was required. Yet the other principle of law flowing from such decision is clearly applicable. It has neither been shown that the director's letter dated 9 October 2012 was given wide publicity, nor has it been shown by the appellant that KPSC had issued any corrigendum, wide public notice, whereby the zone of consideration was enlarged, permitting holders of a Sairang license to participate in the process. We thus hold, drawing inspiration from the said decision, that the aggrieved are all those who had similar or even better qualifications than the appellant, but who had not applied for the post because they were unaware of the fact that persons not having a current LASCA's license would also be eligible to apply and complete the process. Equality of opportunity in matters of public employment being a sine qua non for a fair and transparent selection process, such equality is conspicuously absent in the present case. So in our case also, Your Worship, this clarification given by the state government was not given wide publicity. No corrigendum was issued by the Public Service Commission that all those who have the Bachelor of Engineering Civil and who have that 1 year survey course in their curriculum of engineering can apply for this post. This was not advertisement, no corrigendum was issued. So there are a number of graduates in engineering civil who could have also applied for this post.
Yes.
That is the reasoning the Supreme Court has held. So even in our case, this clarification is valid of Article 16 also, because it has not been given publicity. If there was a corrigendum to the advertisement by the MPSC, a number of BE graduates would have applied for, not only the private respondents. I read para 27.
Yes.
There is one other important aspect which also cannot be lightly overlooked. We shall assume for a moment that though the process was commenced for appointment on vacant posts of LASCA, there was no illegality in persons having Sairang's license being permitted to participate. Of course, there could be aspirants holding LASCA's license in sufficient numbers who might not have the higher qualifications necessary for even appearing for a Viva Voce to aim at possessing a certificate of competency as Sairang. Those aspirants holding a LASCA's license might not also be so capable and or competent for obtaining a Sairang license. After all, individuals are not blessed with the same level of intelligence, human abilities and intellect. The distribution of innate abilities and intellectual prowess being far from uniform, resulting in a diverse spectrum of human potential, it is axiomatic that aspirants having only a LASCA's license can never be considered for direct recruitment on any post in Class 3 of the subordinate service other than a LASCA. It is quite but natural that in the matter of observation, perception and memorization of details of principles of navigation and skill in respect of seamanship, there would be significant differences in the faculties of different individuals. If persons holding Sairang's license were obviously better equipped than persons holding LASCA's license are allowed to apply and participate in the process for appointment on the post of LASCA, the probability of the persons holding LASCA's license being outperformed by persons holding Sairang license would be quite high. It could also be a distinct possibility where all the vacant posts of LASKR are filled up by persons having Sairang's license but not having current LASKR's license as per the statutory requirement. That would pose a real difficulty for persons not so fortunate and lacking in higher intelligence, abilities and intellect, for they would cease to have a level playing field of competing with other similarly qualified candidates and left to compete with candidates having higher qualifications despite the zone of consideration having been specifically carved out for holders of current LASKR's license. It is not that the holders of Sairang license are left in the lurch. Those having Sairang license could well compete for the appointment to the on the post of Sairang in 50% direct recruitment quota along with others having current Sairang's license. If in case all the vacant posts of LASKR are filled up by persons having Sairang license and such holders of Sairang license do not participate in the process for direct recruitment to the post of Sairang, it is very likely that the persons holding LASKR's license would never secure any public employment. This could not have been the intention of a welfare state. So even in our case, the persons who have...
This is somewhat weaker argument.
Yes, but it still applies because they are better equipped. They are graduates in civil engineering. They have so many opportunities for other jobs. Plus, even the recruitment rules of Surveyor 1, if I may take a lordship to the recruitment rules, which is at page, starts from page 21 of the writ petition.
Yes. Same recruitment rule.
Yes, I'm talking about the Surveyor 1, page
Yes.
22, page 8. The schedule is at page 23,
3.
column 6.
Which makes Bachelor of Engineering eligible.
Yes, for the promotional post of Surveyor 1. Number 1, bachelor degree from a recognized university who have completed surveying supervisor course or Bachelor of Engineer Civil from any recognized university. So, Your Worship, they have the opportunity of being directly appointed to the post of Surveyor 1, which is the promotional post of Surveyor. And column 10, 10% by direct recruitment. So, the post of Surveyor 1 is to be filled up 50% promotion, 40% by limited departmental examination, 10% by direct recruitment. So the private respondents who are graduates in civil engineering, they have every opportunity of being appointed to the higher post of Surveyor 1.
Yes.
Para 28.
Just a minute. Yes.
Para 28. Also, it cannot be gainsaid that not only the qualification but nature of duties required to be performed and nature of service to be rendered by a LASKR and a Sairang are different. Merely because the post of LASKR is a feeder post for promotion to the post of Sairang does not per se make the holder of a Sairang's license qualified for the job of a LASKR. Thus, nothing much turns on it. Law is well established that an appointment made contrary to the statute/statutory rule would be void. This is Pramod Kumar versus UP Secondary Education Service Commission. That is Your 2008 7 SCC 153.
Para?
Para 16 and 18. If I may read,
Yes.
Para 16. The qualifications for holding a post, as I also said, page 160. Page 160.
Yes.
The qualifications for holding a post have been laid down under a statute. Any appointment in violation thereof would be a nullity. Para 18 years. If the essential educational qualification for recruitment to a post is not satisfied, ordinarily the same cannot be condoned. Such an act cannot be ratified. An appointment which is contrary to the statutory rules would be void in law, and illegality cannot be regularized, particularly when the statute is in no unmistakable terms says so. Only an irregularity can be. So illegality cannot be regularized. In our case also, Your Worship, the rules are very clear. Even the advertisement is very clear. A graduate from any recognized university who has a 1-year survey course from any government institution, recognized institution. So it is twofold. You have to be a graduate, plus you have to have a survey course of at least 1 year from any government recognized institution. So those are the two essential qualifications. In our case, I admit that the respondents are graduates in civil engineering, but they lack that survey course of 1 year, of at least 1 year, from a recognized government institution. So they do not qualify as per the recruitment rules. I think, Your Worship, paragraph 36 is also important, Your Worship. I'll take your Lordship to paragraph 36. This is the last paragraph.
In their applications, the private respondents, whether they have mentioned somewhere that they have undergone in their graduation course itself, 1 year surveyor course was included.
In
But-
the application,
My lord,
Your Worship,
we have mentioned.
that unless the reports are called for, Your Worship, I don't know. Because the applications have not been included.
It is submitted, my lord. In fact, it's there in the writ petition also, my lord. We have filed it in our reply. No, we had submitted before the MPSC also.
That is to be verified, Your Worship.
And also, my lord, it's in the affidavit. The state government have enclosed it. They enclosed our application in the affidavit itself, my lord. Their certificates.
Certificate is something else. Whether they have mentioned in the application is
No, my lord, I'll tell my
No,
lordship.
I'll come to you.
Yes, yes.
This query was for the petitioner's council.
Your Worship, we are not aware because we do not have access to the applications submitted by the private respondents. Whether they had stated that we qualify as per the recruitment rules because this 1 year service course is included in the curriculum.
Even then, your argument remains that even if same is
It's against the rules.
is required to be allowed, then a
Yes.
corrigendum or advertisement
Has
should
to be
have
issued so that all the BE civil engineers
could have applied.
would have a chance,
Okay.
which has not been done.
Yes.
Para 36, Your Worship,
Para 36.
of the judgment.
Yes.
We hasten to add that whether or not the action of the employer to exclude an aspirant from the process of selection on the ground that either he is overqualified for a particular course or has qualifications which, being over and above what is ordained by statutory rules or rules framed under the proviso to Article 309 of the Constitution, does not match the qualifications specifically required, is justified, has to be decided considering the rules governing selection, qualifications prescribed, nature of duty to be performed, nature of service to be rendered, and a host of other factors. It has to be remembered that at times the employer needs to have the right people at the right place and not always the high qualified has to be conceded. We know of decisions holding that overqualification cannot be a disqualification since such an approach amounts to discouraging the acquisition of qualifications on the one hand, and on the other, such an approach could be seen as arbitrary, discriminatory, and not in national interest. However, this principle cannot be put in a straitjacket, imposing rigid or inflexible rules or norms. Lack of public employment opportunities in sufficient numbers may even force a master degree holder to apply for a job of a peon. But if he is appointed upon his application being favorably considered, what happens to the aspirants who have not had the means of pursuing study beyond 12 standard? Do they remain unemployed forever if all or majority of the posts of peon are filled up by such degree holders? What happens if the master's degree holder, in pursuit of greener pastures, leaves the post of peon for a better and secured higher job commensurate with his qualifications after a couple of years? Does it not in such a case burden the public exchequer by requiring the employer to initiate a fresh selection process? Is not the state a model employer, as a model employer, obliged to ensure that the posts of peon are filled up only by those having the basic qualification and not by overqualified candidates for subserving the common good? Does not the state have the obligation to strive to ensure that all citizens have adequate means of livelihood? These are questions which no court can afford to ignore. We end by saying that each case that comes before the court has to be decided on its own particular facts and problem that it presents for resolution, and that there can be no universally accepted rule that every time a higher qualified candidate is to be preferred to a candidate who matches the essential qualification required for the post. So, well, even the advertisement issued by the state, if I may take your lordship to the advertisement which is at page 65 of the writ petition. Page 65, annexure 3.
Yes.
The number of posts were advertised, Your Lordship. We are concerned with the, although there is no number given, it is at serial number 4.
Surveyor.
15 posts,
Surveyor 1 was not advertised.
not advertised.
Okay.
So as per column 4, bachelor's degree, you have completed 1 year survey course. It is as per the recruitment.
What is the nature of work the surveyor has to do?
Your Lordship, that will be, I think, best left to the government to explain. So, Your Lordship, after the advertisement was issued, even the
In which department these posts were?
Land Revenue Settlement Department,
Land revenue. Okay.
Your Lordship, at annexure 5, page 84,
What is this?
this is the short listing, Your Lordship.
Of the candidates?
Yeah, who had appeared in the written examination, and the candidates have been shortlisted for further screening. I'm just taking your lordship through the facts of the case. After the advertisement, examination was conducted, then there was a shortlisting of the candidates for screening of their documents, etc.
Your name is there.
No, Your Lordship, we have not been included.
In this list also you are not included. Why?
Your Worship,
How the shortlisting was done, on what basis?
that is the.
Your Lordship, I'm for MPSC, they failed in the written examination.
Okay.
That is, Your Worship, now a new thing is, but the fact remains that the respondents, 5 respondents, were not eligible to apply for the post. If they had not applied, there is no reason that we would not have qualified for the post.
No, was there any cutoff mark or you could not get?
Guidelines.
Okay, I'll come to them
Yes.
later.
There will be some guidelines. As per the rules, there is no cutoff. As per the recruitment rules, Your Worship, there is no cutoff. So this was the shortlisting. Then, Your Worship, at page 87, the English translation is at page 90. Page 90, Annexure 6 is the notification issued by the NPSC listing the provisionally accepted list and provisionally rejected list of candidates.
No, therefore I am putting this query. This provisionally accepted list they are eligible to appear in written examination.
No, Your Worship, that is why any person who has a complaint can submit a complaint. Accordingly, the petitioners submitted complaints.
No, this list at page 90,
Yes,
this was published after submission of forms,
after the examination.
after the examination.
Yes.
That means in examination, anybody who applied could appear,
Yes,
even if he does not have surveyors. Suppose a person is not having even a bachelor's degree, could he appear?
no, Your Worship. As per the recruitment rules,
No, that is not my query.
yeah.
My query is, as per the recruitment rule, advertisement was published.
Yes,
In advertisement, the qualification was mentioned,
yes,
bachelor's degree and 1 year surveyor's course.
at least 1 year.
Then the candidates applied for the post. Many candidates
Many
applied. Whether all candidates who applied were called for written examinations or some were. So even if somebody who is not having bachelor's degree, suppose a class 12 pass candidate applies for the, how will you exclude him?
My Lord, may I please?
Yes.
My Lord, because those, they read advertisement, they know their qualification, only coming to know their qualification they apply. And there is scrutiny section that I'll come later on.
No, but the private candidates in this case,
Yes,
7 or 9,
yes.
they know their qualification. They knew that they didn't have 1 year surveyor's course. Still they applied.
Actually, yes, they have qualification and they applied and they have written the examination on 28 and 29 November 2024.
No, my query is, before calling a candidate for written to appear in written examination, whether the Public Service Commission scrutinized the application, that whether they had.
Yes, they do that. There is a
They-
guideline is also there.
No, then at the time of scrutinizing, did you found this 1 year surveyor's course certificate
Yes, Your
of
Lordship.
the present candidates?
Yes,
Private.
we found, and also we saw clarification from the concerned government on 9 August 2024. That also we got replied on 6 September 2025. Then the government replied that those having degree, bachelor, BE, civil are also eligible to
Okay,
apply.
I'll come to you again later on.
Yes.
But the rules were never amended.
No,
Rules were never amended.
not yet.
Rules still required 1 year's surveyor course.
Yes. And also this BE civil also can also apply. BA Civil.
BE Civil,
Those who have 1 year course during their engineering
but
graduate.
rule does not say so.
My lord, because in their syllabus it is there.
No, I don't want, I am not asking for clarification now. Whether rules provided that,
But rule did not specifically provide a separate those diploma or certificate course because it is the government, the employer to decide. There are many judgments, Supreme Court judgment also there. I'll come there. I have judgment.
Okay, I'll come to you.
Yes, because it is the employer to decide the qualifications.
No, my question to Mr. Malhotra initially was, suppose in response to the advertisement, 100 applications were received. So before issuing call letter for written examination, whether the commission would not scrutinize that whether they had the requisite qualification or not.
It appears that as per the documents on record, screening of documents was done only after the examination.
So before examination there was no screening of,
If your lordship will see page 84, annexure 5. Page 84, annexure 5.
what is this?
Your lordship, this is the shortlisting of...
Following candidate who appeared in written examination.
Yes.
That means everybody was allowed to appear in written examination.
Has been shortlisted for further screening. Second paragraph, screening of documents will be done to check if the shortlisted candidates fulfill all eligible criteria. So your screening has been done after the examination was conducted.
And before this 7th April they sought clarification.
Annexure 60. No, Your Worship. Clarification was page 75 of the government affidavit,
Yes, that is dated
6 September 2024. And if your lordship will see,
before this notification at page 84. So when written examination was conducted?
21st, 22nd, November 24.
November 2024.
Yes. Examination was conducted.
No,
Your
no.
Worship.
My query to, I'll put this query to the respondents also, that whether after receipt of applications in pursuant to the advertisement, any scrutiny was done before allowing the candidates to appear in written examination. During that period, any scrutiny was done or not? You don't have the answer.
Don't have it.
They will answer it.
And just before that, Your Worship, if your lordship will see page 75 of the affidavit filed by the state. Affidavit filed by the state, page 75.
Yes, 6 September 2024.
Your Worship, but if your lordship will see the reference, the MPSC had
19/9.
19 September. 19 September. How could they have clarified the clarification before even the clarification was issued? The letter regarding clarification was issued on 19th of September 2024. Page 75. The clarification was called for on 19th of September 2024 by the MPSC. But
Okay.
this clarification is prior to
In the letter dated 6/9/2024, they are referring something.
I think, my lord, this is typo mistake.
Which one is typing mistake?
This reference number,
19/9.
yes.
What it should
cannot-
have been.
Because the reference number, because this letter was prior to this clarification.
Now, where is this letter?
No, it's,
they have not annexed it.
They have-
None of
we
them
have not.
annexed it.
but this is very clear, my lord.
No, it becomes important because this is a private communication between APSC and the government.
My lord, the next one, in my affidavit, I have clarified the note sheet also, in MPSC affidavit also. In my counter affidavit, I have enclosed the note sheet also.
But what
There is nothing hide.
this letter dated 19th of September, if it is wrongly dated also, but they have not annexed it in the affidavit, both MPSC and the state.
Okay. When you put the query to the state government regarding inclusion of BE course, when you put that query?
My lord, from this letter, it will be on 19 August 2024.
19th?
19/8/2024.
From where you are saying?
My lord, for the reference number,
No,
I have not enclosed that.
Reference number?
that is the stand taken by them in the affidavit filed by MPSC.
No. My simple query is, when the MPSC put a query to the government whether BE to be included,
My lord, from the record here, it will be that 19/8/2024.
19/8. From
Well,
where?
From my counter affidavit, Annexure 1 and Annexure 2.
You are respondent number 4 and 5.
Yes, Lordship. Because, my lord, here in my counter affidavit, paragraph 4, I have clarified that it is on 19 August.
No, but on what basis you are saying?
My lord,
What is there to substantiate that it was on 19 August? Apart from your statement,
no, this is
where is the
the
letter?
Parois comment I received from the
The query
government.
could not have been made orally. Query must have been made by a letter. Where is that letter?
My lord, this I'll go. Kindly read, Lordship, para 4.
It has not been annexed. That is the problem.
Para 4. May I
Of
kindly read?
your affidavit.
Yes.
Yes.
May I kindly read? Very short. In
No,
response.
there you have mentioned 19 August.
Yes. That is typo mistake.
But that has not been annexed yet.
No, this is the same one, Your Lordship.
No,
Yeah,
you
we have not annexed. I admit that, Your Lordship.
you are saying typo mistake in the letter.
This reference 19/9 should be 19/8.
Which has not been annexed.
No, that is your stand.
Yes.
Typographical mistake may also in the paragraph 4.
Yeah, but
instead-
here I have clarified.
No, instead of August, it should have been September.
Yes.
From the letter, it appears that instead of August, it should have been September.
Yes.
You have clarified that there is a typographical mistake in your affidavit.
But actually, my lord, that it is no this thing predicament or prejudice to all the parties. This between just August and September.
No.
Contents are very important.
It is on that basis you have allowed the clarification you have allowed the private respondents.
Yes.
Therefore, it carries a significance.
And also, my lord, if you kindly,
Okay,
to
I'll
substantiate
come-
my statement, there is a note sheet
Okay, I'll
also.
come to you. First, Mr. Malhotra, let him finish. Yes.
So, Your Worship, this letter written by the MPSC to the government in this page 75, the reference is 19th September 2024, but the MPSC in the affidavit says that it is 19th August 2024.
Yes.
But Your Worship, they have failed to produce it. Both the state government as well as the MPSC have not annexed this document in their affidavits. And my learned friend, the counsel for MPSC, had stated that the petitioners had not qualified in the written examination. But that is not stated in the affidavit. In their affidavit, they have not made even a whisper that we did not qualify. And the recruitment rules does not say that there is a qualifying mark that there will be a written examination also.
Okay. Anything else?
Yes, Your Honor, if I may be given a chance to submit a reply later.
Yes. Yes, respondent side. Who will submit? State is,
The state respondents are 1 to 3.
what is your stand?
My lord, our stand is that all the petitioners along with the private respondents, they are qualified to participate in the exams.
How?
Because they have all possess a bachelor's degree along with a survey course of 1 year. All of them, my lord, they are all qualified. In fact, if we had not allowed the private respondent, it would be more wrong, my lord, because they have a survey course. My lord, I'll take a lordship to my affidavit. And first of all, my lord, I'd like to take a lordship to the rules.
No, just a minute. Where is the rules are in 21, page 21.
My lord, in my affidavit, it's at page 78. It's the same rules, but I'm referring to my affidavit, my lord. Page 78 is the recruitment rules of 2021. These are for the post of Surveyor 1 and Surveyor. At page 80, my lord, the educational qualification at page 80.
Yes.
I'd like to take a lordship to Surveyor 1. Surveyor 1, which is a higher post, my lord.
Yes.
At the column number 7, my lord. 7. Bachelor's degree from a recognized university who have completed surveying supervisor course or Bachelor of Engineer from any recognized university. So even for a higher post, my lord, the educational qualification that is required is a bachelor's degree from a university and any person who has completed surveying supervisor course. This is for the higher post. And my lord, the second educational qualification is Bachelor of Engineer Civil from any recognized university. Here, my lord, nothing is mentioned about surveying course, so it's deemed that they already have a knowledge of surveying.
No.
So even for the higher post,
No,
it's
my
not
query
required.
to you is, when for the post of Surveyor 1, you have specifically mentioned BE
Yes.
Civil to be an eligibility criteria. The rules could have provided for surveyor's post also an alternative qualification of BE to be an eligibility criteria, but that was not done.
That was not done because, my lord, it's a bachelor's degree anyway, my lord. Bachelor
No.
of Engineering.
When you have mentioned specifically in the rules the eligibility criteria against surveyor 1 post,
Yes.
that BE would be a candidate having BE would be an eligible candidate. You have not done so in for the
Yes,
post
my
of
lord. For the
surveyor.
post of surveyor, it's not mentioned. That is true. But however, my lord, it's all a bachelor's degree from a recognized university, along with a survey course of 1 year. So they fall in the category of this bachelor's degree along with a survey course of 1 year, the BE Civil. That is why a clarification was sought by the MPSC, and after thorough discussions and, my lord, after seeing all the documents, it was decided that they are eligible for giving the entrance examination.
No, why then in rules it was not specifically mentioned as an alternative qualification, as has been mentioned for surveyor 1 post. In surveyor 1 post, apart from bachelor degree and 1 year surveying supervisor course, an alternative qualification has been mentioned in the rules itself. But for surveyor's post, no such alternative qualification has been.
My lord, the bachelor's degree is inclusive of this BE Civil, and are there
Yes.
any bachelor's degree?
Yes,
my lord?
yes. Even if we assume that BE Civil is also a bachelor's degree, then a requirement of 1 year course from a government institute is there as per rules.
It's there, my lord, and according to the syllabus, my lord, it has a survey course of 1 year in 2 semesters. My lord, I have annexed all the documents, all the certificates of the private respondents. I'll take your lordship to my annexure, my lord.
No, your contention is that, first contention is that BE is deemed to have, those who have qualification of Bachelor of Engineering are deemed to have done 1 year survey course
Yes,
because it is included in their syllabus.
in the
That is,
syllabus.
that is your submission.
Yes, my lord, that is.
And second submission is that the candidates who have been private respondent who have been selected have shown that their syllabus included this 1 year course.
Yes, my lord, 1 year course.
Okay, any other submission? Where? Show it to me.
My lord, it's in the annexure. From page 13 onwards, my lord.
No, show one instance.
Yes, my lord, I'll do that. At page 14, my lord, this is in regard to the Lalram Heta, one of the private respondents.
Yes.
At serial number 7, surveying practice 1. And the next page, at page 4.
No, it is
15.
one of the subject.
Yes, my lord. It's a 1 year course.
1 year
in
1
2
year.
semesters, yes. And the next page, my lord, this is also
And
the
what
same
is the
person.
course provided by the government recognized institution for what is the survey course? What is the syllabus of the survey course?
The syllabus, my lord, it's not mentioned, and even the recruitment rules only provide for a 1 year surveying course. Whether the syllabus are similar or not, my lord, I cannot say. But the rules, the recruitment rules only provides for a 1 year surveying course. With regard to, my lord, this page 14, Lalram Heta, at page 15 is a continuation of the other course, my lord.
No, page 14. How can you say that this is a one-year course, this serving practice?
This is semester and examination, my lord. This is for the academic year 2013 to 14 at the top right-hand side, my lord. And number 4 is surveying 1 and 7 is surveying practice 1.
No, from the mark sheet which you have annexed at page 14,
Yes, my lord.
it appears that this is a mark sheet of third semester examination, where surveying 1 and surveying practice 1 were 2 of the subjects, along with many other subjects. How it shows that it is exclusively 1 year surveying course?
My lord, in the next page is the 4th semester of the same person, Dalram Hutta. Page 15. This is the 4th semester BE grade card. And the subject is at page 4 and 7. Not page, my lord. Serial number 4 and 7. Surveying 2 and surveying practice 2. This is the 4th semester. And the next page, again for the same person, my lord. In the 6th semester also, at serial number 8, extensive survey. This is the 6th semester BE grade card.
What course is provided by the government institution for?
My lord, I'm not aware of the course, my lord.
No, if you are not aware, how can you say that this is equivalent to? If you are not aware about A, how can you say B is equivalent to A? You have to know about A course, and only then you will be able to compare B course with A course.
My lord, I think that the private respondent can answer, my lord. I think they have included in their affidavit.
No, you have given clarification to the
Yes.
Public Service Commission. In your clarification, you have stated that this may be BE Civil may be eligible without making any amendment to the rules. You could have amended the rules. Without amending the rules, you have given that clarification. Now you have to convince this court that what was the basis for this clarification.
My lord, like I have stated, my lord, the rule says a bachelor's degree of any university along with 1 year survey course.
Yes, that means bachelor degree plus 1 year survey course.
Yes.
Suppose
Bachelor's degree,
it is Bachelor of Arts, then Bachelor of Arts plus 1 year survey course. You are saying as because it is Bachelor of Engineering, that additional 1 year survey course is not required.
since they already have a
But you have not stated so.
1 year survey course, my lord.
That was my query. You have not stated so specifically in the rules as you have done in the case of Surveyor 1. For the post of Surveyor 1, you have stated specifically that if somebody is having Bachelor of Engineering Civil he need not to have the 1 year survey supervisor course.
Yes.
Okay. Okay. What else is your stand?
My Lord, I'd like to say that my Lord, the petitioners have all accepted the advertisement and the entire process of recruitment and have duly appeared in the competitive examination. And only after finding out, my Lord, at the belated stage that they have not come out successful, they have approached this court. And their representations were submitted and it was carefully considered by the state government. And it has been accepted, my Lord, the representations were accepted and a clarification was made by the state government at this. And my Lord, I'd like to take a lordship to para 9 of my affidavit. The reason why we have opened this White Avenue at page 5, para 9.
Yes.
May I read, my Lord? It's a little bit long. I'll read the whole thing.
Yes.
That with regard to the statements made in paragraph number 14 of the writ petition, I say that as stated in paragraph number 4 and paragraph 7 of this instant affidavit, the candidature of the candidates who possess BE certificate was accepted as per the clarification of the state government. The qualifications stipulated in the recruitment rules by the Mizoram Gazette extraordinary notification dated so-and-so, page number so-and-so, clearly states that bachelor's degree from a recognized university who have completed at least 1 year survey course from any government recognized institution, which has been made by the government with an intention to open avenue for entry of civil engineers from recognized universities for recruiting competent personnel besides trained surveyors who pass from survey training institutes. Surveyors were initially recruited in the past years from the qualification of metric, having 1 year diploma in survey training, who were found rather incompetent and having limited ability to perform departmental works and duties requiring English writings and speaking, etc. The department therefore felt it necessary to recruit more capable person for the post, as they have avenues for promotion up to the level of Joint Director of Surveys. Therefore, the respondent candidates were recommended by the respondent number 4, and their participation in subsequent recruitment process could not be denied by the respondent number 4 for recommending them for appointment. The candidates were recommended for appointment as they were found to be duly qualified and eligible for the post in accordance with the prescribed recruitment rules and criteria, and also with higher marks obtained by them. So, my Lord, there is nothing wrong in allowing the private respondent to compete in the examinations. In fact, this was done for the betterment of the department, my Lord, so that we could engage more capable person for the post of survey. And I'd like to say that, my Lord, there is a fair and transparency in the entire process. There is nothing wrong in this, my Lord. We have accepted the candidates who are eligible for the examination, and they have given their examination. Even the petitioners, they have accepted the examinations.
No, what is your response to the submissions by the learned counsel for the petitioner that
Yes, my Lord.
had you mentioned in your application, in your advertisement that BE would be eligible, would also be an eligibility criteria.
Yes.
More candidates
More-
possessing the
yes.
said degree could have applied. You could have got better candidates.
My Lord, I think that is not the case in the present case.
That is one of the
That is
submissions.
a submission, but for them, if we had advertised and more capable person comes, my Lord, they'll have more competition. That will not be, that is not the case in this, my Lord. The citation which my learned friend has produced is that they have higher qualification. However, in this case, my Lord, they wanted more competition. That is what they are saying. That is not, my Lord, it's not very relevant in this case, my Lord. had they have higher qualification, if they are the BE civils who have not competed in the examinations, only after finding out that some were already successful, had they come to this court, my lord, it would have been applicable. However, this is not the case, my lord. The situation is different. That is my point in that, my lord.
Okay.
So, my lord, I'll say that this, they have, the petitioners have accepted the advertisement, the recruitment process and the examination. Only after finding out that they were not successful, they have come before this court. And
No, their case is basically that some of the candidates who do not possess the requisite qualification
yes,
as
that-
per
that
the
is
rules,
case.
as well as per advertisement, were selected without there being any change in the advertisement or change in the rules. That is basically their case.
And our contention is that, my lord, the rules has stated very clearly a bachelor's degree from any university and a survey course of 1 year. Does not mention what course, but a course of 1 year. So, according to the government, my lord, all the petitioners as well as the private respondents, they are eligible to participate in the examination. Okay.
Yes. You are 4 and 5.
Yes, Lordship, for MPSC,
What is your name?
JC Lalmun Sanga.
This item number
Is there in the
five.
course, in the course list?
Yes.
My lord, I'll be arguing questions of law because fact it is quite clear now. So
Yes.
two grounds I have. One is like any candidates who participated in the exam, it is held by Supreme Court recently also in many judgment also, participated in the exam and became unsuccessful at the end. They are expelled from challenging the recruitment process. It is laid down by the law. I have given the citation also, that is one. Because they knew that they have not cleared the exam, and I'll project the dates also. Then
No. Their case is some ineligible candidates were allowed to compete with them.
Well, they have
Therefore,
to,
they were excluded.
that's why they have to come and approach the court earlier, before the selection process was completed. That is my point. Second point is that, my lord, Supreme Court also held in many cases that it is the employer to decide the qualification. If there is any ambiguity and anything dispute, because the employer is the best the judicial review is the scope of intervening in this case. That is 2 points. My lord, before I go those 2 points, I'll just recapitulate very short, brief fact. Exam advertisement was published on 9 July. This is very important. 9 July 2024. An exam was conducted
Yes.
on 21st and 22nd November the same year.
Yes.
And I'll just go back to what you asked me before. Before that, they scrutinize, they have general scrutiny of their qualification, age, and some other things.
Before examination?
Since it is done through online.
Okay.
Everything was online. Then there is a stage where they require detailed certificates, everything, and they have to bring that physical and they have to come. I'll come later on. First they advertise and they had scrutiny and they conduct exam on 21st,
After scrutiny,
exam.
you do not exclude anybody.
Yes.
You
Then we
allow,
issue
you
admit
allow
card.
everyone who has applied.
No. We scrutinize those who qualified. We issue admit card. Here also.
And
it is.
those who don't qualify?
My lord, in this case, there is no such people, those who are disqualified. Normally, they know their qualifications.
No. This query, why I am putting this
Yes.
query? Because you raised a query to the government after written examination.
Yes.
Why this query was not raised
No.
before written examination?
The first scrutiny was through online. It was general scrutiny. Online, they did not submit that details document certificate.
No. For general candidates having general graduation degree,
Yes.
apart from their degree certificate, they also submitted some certificate of undergoing surveyor course. There were two certificates for general candidates.
Yes.
And only for those who are possessing B's, they submitted only one certificate, their B certificate.
Actually, there is a stage where we required them to submit. On I think 7 July, we required them to submit. I'll just come the brief fact first, the dates. And we had general scrutiny, and we issue admit card, and we conduct examinations on 21st and 22nd November. And result was, this is important, and shortlisted candidates was notified on 7 April 2025. This is results of successful candidates in the written examination.
Written examination.
Yes, on 7 April. My point here is not very important. Here, they could have filed writ petition. They just should not sleep and wait. So then, they knew that here at this stage, on 7 April 2025, they knew that they are not qualified, they have failed in the examination.
No, but they, at that point of time, did they knew that the candidates who have qualified do not have a separate...
Actually, they knew. They filed representation also. I'll come. They filed representation on 10 July 2025. Then after this first shortlist on 7th April 2025, an MPSC issue provisional rejected and provisional rejected and selected list on 4th June.
Yes.
Yeah, they check very carefully their documents, everything, and they issue notification for provisionally accepted and provisionally rejected list on 4th June. And after that, they file representation. If you kindly see their representation, Your Lordship, it starts from page number 93 of their writ petition. Page number 93.
Yes.
Sure. My Lord, they are one and the same. Their contention is that they knew that somehow the qualification and the syllabus prescribed by the MPSC and those they had in their syllabus during degree course are somehow not similar. And they project those difference, those qualifications. Because for surveyor, the natures of work requires measurement. They go to field, they go to land, they take measurement, they take degree, they take those surface degree, distance and all. So mathematical calculation requires a lot. So then the syllabus, my learned friends, private respondent enclose everything. But here in their representation, they mention clearly that they are somehow not similar, they are different. But they are not the competent authority to decide as per the ruling, the Supreme Court ruling also. So they, not only one, another petitioners also, even Samuel also submitted, and Isaac also, and they agitate that the syllabus or the subject, the course they have are somehow different or not similar, not aligned with the requirement of the job, the natures of work for surveyor. So Lordship, then on this representation is on 10 June, and they did not, it was not replied, and they did not go to the court, and again on 8 July. 8 July is important. And final accepted and final rejected lists were notified again. This notification was published in internet, and Mizo MPSC, for all communication we used internet, we put on internet website, official website. This is on 8 July, and after 2 days, then we declare final result of those who successfully. Lordship, in this respect, I would like to take you to your. We requested them to produce their documents and their educational qualifications, everything.
Whose?
To those who were successful. On 8 July,
What is the syllabus of surveying course, 1 year surveying course?
yes, my lord, here that the explanation we got from that department is that it is not a separate certificate, it is not a separate diploma certificate course, but if they study that course in their engineering course, engineering degree, then it was accepted.
No, that is okay. That clarification. My query is, what is the syllabus of that 1 year surveying course as required, as mentioned in the rules?
Oh, it is. We have not enclosed. It can be downloaded from the internet, and private respondent enclosed in their petition. And we also compare. It's somehow similar. My lord, if you kindly see 109 page, 109. This is final shortlisted result on 10 July 2025. The last sentence.
Yes.
Here, candidates should bring in the following documents original at the times of interview. Candidates marks. Well, before that, we require them to submit documents. I'll just take you to page number 86. Petition. Read petition number 86.
Yes.
Yes. So we require them to submit their certificates and mark sheet also, so that we can see that whether that the subject aligned to the requirement. And all the syllabus is there in the read petition filed by the private respondent also. Details, subject, topics, everything is there. So my lord, then results were announced on July 10, 2025, and recommendation was made on July 30. So this is very short, and they filed this read petition, I think on, petition on August 2025. After everything, after final results were declared, selection candidates and successful candidates were notified, and also recommendation, in fact, were also issued. Just before final appointment order, this case was filed, and they sought for interim order, stay order, and they received stay order.
Now what is your submission?
Now my submission in this point is that, Lordship, I'll take you to this judgment. Pradeep Kumar, 2015, volume 11, SEC 49. before I go to the relevant para, the very brief fact of this case is that there is appointment recruitment in UP, that is the appointment for SI, that 50% is from direct and 50% from constable and head constable. So regarding the vacancy they challenge. So it had come up till to Supreme Court. So then that the constable and those head constable, they challenge recruitment process after declarations of the result. So what the Supreme Court laid down is that you had the opportunity to challenge. You knew that and you had to challenge before that. Before, you cannot blow hot and cold at the same time. So no one can challenge recruitment process waiting for...
No, this is not an absolute law.
My Lord, I'll take you to para number 17.
Show me.
Para 17, this is the... Moreover, we concur with the division bench on para 17.
17.
Barry? Pradeep Kumar Ray versus Dinesh Kumar Pandey.
Yes, in the light of
Para 17. 1-7. It starts with moreover.
yes. Moreover.
Moreover, we would concur with the division bench on one more point that appellants had participated in the process of interview and not challenged it till the results were declared. There was a gap of almost 4 months between the interview and declarations of result. However, the appellant did not challenge it at that time. Thus, it appears that only when the appellants found themselves to be unsuccessful, they challenged the interview, and this cannot be allowed. The candidates cannot approbate and reprobate at the same time. Either the candidates should not have participated in the interview and challenged the procedures, or they should have challenged immediately after the interview were conducted.
No, here challenge to procedure was made.
Yes.
But in the instant case, they are challenging the eligibility criteria of candidates whom you have.
No, they don't. My Lord, they have not challenged the notification 7 April. They have not challenged that July 7 July also, shortlisted candidate also, final provisional rejected list also they have not challenged. Even they have not challenged this, the result, final results also. They have challenged only the appointment, recommendation. If you kindly see the petition also, they have not challenged. They should have challenged this, the first 7 April shortlisted candidate also. My Lord, this judgment was relied upon by a single judge by this honorable court. So my Lord,
No, facts are different.
facts actually here in this
Facts
case.
are different.
No, my point is that they challenged belatedly. Here in this case
No,
also,
every belated challenge.
yes,
here-
my Lord, they should not participated.
Where? In the recruitment process.
Yes.
Because they are not challenging the
You know, the
advertisement.
petitioner would have challenged before 4th April, or when he came to know he was not selected. He should have challenged that 4th
No,
April.
they are not challenging their non-selection. They are challenging that you have selected, their case is that you have selected ineligible candidates, and which they came to know when they came to know about their
And
choir.
they came to know on, we put on website, they came to know, they put on 7 April. They have not challenged this one.
Where is that notification?
My Lord, you kindly see this notification 84.
Page number
84, petition, page number 84.
of the writ petition.
Yes, Lordship.
But here you have not stated about the qualification of the challenge.
My Lord, here,
How they will come to know that whom you have shortlisted were having an additional surveyor degree or not?
my Lord, they know when they file representation. They file representation. They knew and they file representation.
They filed
Yeah,
representation.
representation, they filed it. They filed representation on 10 June. On similar line, they filed representation.
No, they have filed representation after this
They filed representation on 10/6/2025.
10/6. So you can say that by 10/6 they had the knowledge
Yes.
and they,
No, we can presume that they had a knowledge on 7 April when we put on our official website.
how will you presume?
My lord, we publicize all communications in our official
No,
website.
Mr. I am unable to understand. When you have shortlisted the list of, when you have
On 7 April?
on 7th April you have published the shortlisted
Yes.
candidates.
Yes,
You have not published their qualifications.
we have not.
How they will know that they were not having the surveys, separate surveys, 1-year course degree?
My lord,
They will, on seeing that notification of 7th April, only information that would have been, they would have known that these candidates were selected.
my lord, here,
They
When-
could not have challenged that notification.
anyway, if presuming that they do not know that, not admitting that, and they filed representation on 10 June 2025.
Yes,
So before we go further, they could have filed a petition. Then we'll stop everything. Everything will be stalled.
yes, that may be a submission.
Yes,
On 10 June, they
they knew, they filed representation, and then they could have filed everything. And also after that, on 8 July, final provisional, final accepted and this rejected this was also again publicized in our official website. So my point, in view of the Supreme Court judgment and the judgment passed by coordinate of this bench, I have furnished this judgment. Lordship, you kindly go through.
which para you are relying? What were the facts?
My lord, a fact is that that the petitioner challenged that for the appointment of officers in education department, and that lady, he knew that she was overage, and he also filed representation. Despite knowing that she was overage, he participated in the process examination, also participated in the interview. Then after he was not selected in the interview, he filed a writ petition. So it is there, and the court clearly mentioned, I have marked it.
But in the instant case, after appearing in written examination, only after, when the written examination was held,
Here written examination on November 21 and 22.
no, in the instant case.
21st November and 22 November 2024.
24. But
Yes.
at that point of time, he was not knowing. The knowledge came in the next year, June only.
No, even he knew that. Even he knew that on 10th June, when he filed representation, he kept quiet. They have not come to the court.
Okay. This judgment which you are referring to, which paragraph you are referring?
Para 16.
Yes.
In case of Pradeep Kumar and others, Apex Court concur with decisions of the Division Bench of the High Court on the point that the appellant had participated in the process of interview and did not challenge it till results were declared. There was a gap of 4 months. Hello, I have marked it.
When stay was granted in this case?
In this case, I think on the first day, stay was granted on, when the case was filed, on the first day at motion stays.
Okay, okay.
But subject to outcome of this writ petition. So, my lord, I'll just to sum up my one low point, that I'll not come into the regarding the similarity of the course. The petitioners here, they have not challenged the shortlisted candidate which was issued on 4th April, and also the provisional rejected list also they kept quiet, and they only filed it petitions belatedly when all the results were declared, successful candidates were declared. Well, they have not cleared the written examination conducted on November 21 and 22, 2024. So the Supreme Court held that they cannot challenge afterwards. This is the law laid down by the Supreme Court. And my second point,
Yes.
my second point is that it is employer to decide who are best fit for the appointment regarding the qualifications also. Because in this case, as I submitted earlier, surveyor, because now that the department also now they are pressurized to expedite the case. In Mizoram, there are lots of pending work regarding survey. There are many developmental works. So we have very few surveyor as of now. So the works of the surveyor in land revenue
No,
department.
there would not have been any dispute had the rules were clear. The alternative.
My lord, if here it is what my submission as per the Supreme Court judgment is that it is the employer who knows the requirement, the natures of work. And so they, because MPSC without, and there is a query also, so that we had short clarification. Just now I got that the clarification, may I kindly pass on?
Yes. Clarification you have annexed in.
No, I have not annexed my clarification application. I have the reply only.
Okay, this is.
So the first one is the
19th August.
Second is the translation. May I kindly read? Because my learned friend also require, I have only one copy.
Yes.
Application for clarification. My lord, it is there in 19 August 2024.
Yes, that was the query.
Yes. Undersecretary DPNAR General Service Wing subject application for clarification. Madam, with reference to the subject cited above, I am directed to convey the following to you. MPSC is presently conducting a recruitment process to fill up 15 vacant posts for surveyor under Land and Settlement Department. As per eligibility conditions prescribed in the recruitment rules for applying to the said post, at serial 1 it is stated as bachelor degree from a recognized university who have completed at least 1 year survey course from a government recognized institution. In this regard, the Commission seeks clarification as to whether completion of a separate 1 year survey course is mandatory, required, or whether candidates who possess a bachelor degree wherein survey is studied as one of the subjects for a period of 1 year, for example, BE civil degree holders, may also be considered eligible for the said survey recruitment. Yes. The Commission therefore requests that this matter may kindly be clarified and communicated to the Commission at the earliest. My Lord, this continuation of this one, I have my Paraguay's comment. If you kindly go to my Paraguay's comment, my Lord, affidavit.
Yes.
And I received Paraguay's comment on this basis, and page number 6. This is the reply of this letter, 19 August 2024. Page number 6. With reference to the letter, may kindly read?
Yes.
With reference to the letter, number and subject mentioned above, I am directed to inform you that the government in DP and AR GSW has considered the qualifications of BA Civil as acceptable for direct recruitment to the post of surveyor, provided that a one-year surveyor course is included as one of its subjects. And also, my lord, the next one, note sheet also we have enclosed. With reference to the proposal for clarifications on whether a candidate possessing the prescribed qualification for direct recruitment to the post of surveyor is also eligible for direct recruitment to the post of surveyor under Land Revenue Department is informed that a candidate with BE degree appears to be eligible for direct recruitment to the post of surveyor as the degree includes 1 year survey course and one of its subject. My lord, here my point is that here there is confusion, ambiguity, so that the Supreme Court I have referred at para 9 can clarify regarding judicial review in respect of this confusion.
Where? Para 9
Para 9.
of your affidavit?
No, para 9 of the judgment.
Which judgment?
Citation number 2019, volume 6 SCC 462. Maharashtra Public Service Commission versus Sandeep Sriram Warre and others. This is very brief fact of this case is that there is a promotional dispute, then that the officers who claim to have certain qualifications and length of practice, they are denied and they challenge and it come up to Supreme Court. And para 9.
Yes.
Can you read? Essential qualification for appointment to a post are for the employer to decide. Employer may prescribe additional or desirable qualifications, including any grants of preference. It is the employer who is best suited to decide the requirement of a candidate must possess according to the needs of the employer and the nature of work. The court cannot lay down the conditions of eligibility, much less it delve into the issue with regard to desirable conditions being on par with essential eligibility by interpretive rewritings of the advertisement. Questions of equivalence will also fall outside the domain of judicial review. If the language of the advertisement and the rules are clear, the court cannot sit in the judgment over the same. If there is an ambiguity in the advertisement or it's contrary to any rules or law, the matter has to go back to the appointing authority after appointing orders to proceed in accordance with the law. In no case can the court, in grasp of judicial review, sit in the chairs of appointing authority to decide what best for the employer and interpret the conditions of advertisement contrary to the plain language of the same. Here, my lord, my learned friends enclose each and everything regarding their syllabus, the course, and there is a detailed comparisons also conducted by the NPSC also. So my lord, the course BE Civil, they studied all these civil works, survey works, and everything. It is there in their course. That's why we accepted, and that's why the Supreme Court said that requiring and considering the natures of our surveyor in the Land Revenue Department, those BE civils are much more better than those simply have 1 year certificate course from Mizoram. So, and here in their decision also, they need those who have mathematical technicians and those who studies this kind of drawing everything. So that's why we selected as advice from the government. So the law is well settled in this respect. So these two submissions I have made. So my point is that one is they cannot challenge after they are not selected. And number two is that the employer is to decide who are best suited for the one. And also MPSC relied upon the observation received from the DPLAR who are the employer for these candidates for this one. That's I raise my submission, Your Lordship.
Your respondent number? Private respondents.
Now, my lord, let me start with the comparison of the course that your lordship had raised. Now, my lord, if your lordship will see page number 56, my lord,
No,
of our
no.
affidavit.
First, the query posed by the MPSC
Yes.
to the government is a relevant query, that whether a separate course is required or whether if it can be shown that 1 year surveyor course is included in B can also be considered as fulfilling the terms of the eligibility criteria. So, yes, now make your submission.
So, in that respect, my lord, my humble submission is, my lord, if we look at the advertisement and also the rules, my lord, the rules nowhere, though the advertisement nowhere says, my lord, they have to be from a separate institution. It nowhere says like that, my lord. It simply says, my lord, if we look at the advertisement, it says
Who
1
have
year.
completed at least 1 year
Correct.
survey course.
Correct. With, it says, bachelor degree with 1 year surveying course. So it does not say that institute has to be from a separate.
It also even do not uses the term with. There is no with. Bachelor degree from a recognized university who have completed at least
Yes, correct.
1 year survey
Correct.
course.
Who have completed. So there is nothing that says, my lord, it has to be from a separate university.
Okay, we'll continue.
We'll continue.
To before you start, other matters I may not be able to take up today. So you may take your convenient dates from the court master for other matters.
Yes, we have given, my lord. During the break, my lord, the court master had informed us, so we had given the
Okay.
dates.
Then we'll continue with this. Yes.
So if it may please the court, my lord, your lordship had raised that question before we had the break, my lord. And the question your lordship had raised, my lord, this is my humble understanding. That is the basic issue in this case, my lord. Yes. The issue in this case, my lord, is whether that surveying course
Has to be done separately.
or whether it will be acceptable if it is not done separately. That is the issue that I understand, my lord.
Yes.
And my argument in this respect is that even if it's not done separately, then it is still within the.
But then a
parameters
query is, when for the post of surveyor 1, it has been specifically mentioned that BE would in itself be sufficient. This could have been mentioned in surveyor post also, had that been the intention.
No, my lord, my humble understanding is this, my lord. Then I'll provide your lordship with some Supreme Court judgments. Now, the Supreme Court, there is one case where the Supreme Court has stated, my lord, if it is the intention of the government, my lord, if it is the intention of the government to exclude certain people who have overqualified, like who have more degree than the basic degree holders,
Yes.
then in that case, the government has to clearly spell out in the act,
Okay.
in the rule it says. And my humble submission is this, my lord, because the rules are so clear. When the rules are clear, my lord, the intention of the government, of course, my lord, we can always debate on what would be ideal and what would have been better. But my lord, my humble submission is this. It's a Supreme Court judgment, my lord, that the intention of the government has to be gathered solely from the rule itself, the words of the rules itself, my lord. And my lord, if I may take your lordship back to the rules, my lord, relevant rule at page 24 of the writ petition, my lord. Let's read this one more time, my lord.
Yes.
Page number 24. My lord, I'll read.
Yes.
My lord, it says like this: bachelor's degree from a recognized university who have completed 1 year surveying course from, my lord, the use of the word any is also something I think we should note, my lord. Any government recognized institution. Now, my lord, this is how I understand. Nowhere does it mention, my lord, that the 1 year surveying course has to be from a completely different university. As long as, my lord, it is from a recognized institution, that's what it says, my lord. And also, my lord, does not mention that it has to form a separate course. That word separate is not used anywhere, my lord. It simply says bachelor degree from a recognized university who have completed at least 1 year surveying course from any government recognized
So
institution.
it may be within that bachelor course itself.
That's how the
that
word
1 year.
yes, because it's framed so broadly, my lord. And the intention of the legislation has to be gathered from the words itself. So because of this reason, I'm saying, my lord, that it can be included. And if your lordship will come to the advertisement, which is at page 65. Now the advertisement, my lord, is more or less in line with the rules, but is even more brief. My lord, it says like this: bachelor's degree, who have completed 1 year surveying course. My lord, simple, nothing else, my lord. No use of that word separation, nothing of that sort has been done, my lord, in this. So in that view of the matter, my lord, my humble submission is, because this is a simple interpretation of statutes, we will have to go by the words that are provided in the statute and in the advertisement.
Yes.
My lord, I would like to cite a Supreme Court judgment in this respect, my lord. This is reported in 2014, volume 6. 2014, volume 6, SCC 333. Sorry, SCC 335. SCC 335.
Para?
My lord, the relevant paragraph is at paragraph number 22 at page number 345 till paragraph number 23. At page number 345, my lord, towards the bottom, you'll see paragraph number 22. My lord, I will read paragraph number 22. It's just like this, my lord. It is cardinal principle of interpretation of statutes. My lord has got it?
Yes.
It is cardinal principle of interpretation of statutes that the words of a statute must be understood in their natural, ordinary, or popular sense and construed according to their grammatical meaning, unless such construction leads to some absurdity or unless there is nothing in the context or in the object of the statute to the contrary. The golden rule is that the words of a statute must prima facie be given their ordinary meaning. It is yet another rule of construction that when the words of a statute are clear, plain, and unambiguous, then the courts are bound to give effect to that meaning, irrespective of the consequences, my lord. It is said that the words themselves best declare the intention of the lawgiver. The courts have adhered to the principle that efforts should be made to give meaning to each and every word used by the legislature, and it is not a sound principle of construction to brush aside words in a statute or being in opposite surpluses if they can have proper application in circumstances conceivable within the contemplation of the statutes. It is also a well-settled principle that the courts must interpret the provisions of the statute upon ascertaining the object of the legislation through the medium or authoritative form in which it is expressed. Authoritative form, my lord, means the express words of the statutes, my lord. It is well settled that the court should, while interpreting the provisions of the statute, assign its ordinary meaning. So this, my lord, the next point goes into purposive interpretation and beneficial legislation. I'll read paragraph 24 also, my lord. This court in Shyam Sundar versus Ram Kumar has observed that in relation to beneficial construction, the basic rules of interpretation are not to be applied where 1. The result would be re-legislation of a provision by addition, substitution, or alteration of words, and violence would be done to the spirit of legislation. My lord, supposing, my lord, we go by the interpretation given by my learned friend, we will have to add the word separate. My lord, that is not something the law says is allowed, my lord. Second, the words of a provision are capable of being given only one meaning, and where there is no ambiguity in the provision, however, the courts may apply the rule of beneficial construction in order to advance the object of the act. So even if we were to give the beneficial legislation, my lord, forget literal interpretation or ordinary meaning, even in that case, my lord, it could have not been done because we will have to add words to these rules. And my lord, there's another Supreme Court judgment on this point, my lord. This is reported in 2007-5. 2007-5 SCC. My lord, I'll take your lordship directly to the relevant page. I think your lordship has got the book 488, my lord. The citation is, my lord, 2007-5 SCC 447. 447. The relevant paragraph is at page 488 at paragraph number 92. My lord, paragraph number 92, my lord, will see from around the middle, my lord, your lordship has seen omission of words.
Yes, omission of words.
Yes, my lord. Omission of words in a particular statute may play an important role. The intention of the legislature must be, as is well known, gathered from the words used in the statute at the first instance, and only when such a rule would give rise to anomalous situation may the court take recourse to purposive construction. It is also a well-settled principle of law that casus omissus cannot be supplied. My lord, in our case also, omission of the words like separate, my lord, plays an important role.
Yes.
And from the words itself, my lord, it is indeed clear that the government's intention has never been to isolate students, my lord, who have that kind of degree where surveying course has been made one of the subjects. And it is in line with this, my lord, that the government of Mizoram had interpreted the rules also. it is not an isolated interpretation. It is in line with this interpretation that the government of Mizoram has also given that interpretation. My lord. And I will not read that letter again, my lord.
Okay, that clarification
That
to
clarification is
commission.
the interpretation. That is my first submission, my lord. And there is one more judgment which I would like to cite, my lord. This one was reported in. This one was from 2002, my lord. I have given the site. I have given the printed copy from Kanun.
Read it later on, you give me.
It's your, my lord. I'll sorry. Sorry, my lord.
What
My lord,
is the
this
citation?
My lord, this citation is from
SCC citation.
AIR online is there, my lord. AIR
Yeah.
online 2002 SC 320. Now, my lord, this in the last page,
Para 9.
para 9 last page, my lord. I will read only the relevant portion. My lord, your lordship will see in the event.
Yes.
I have marked it, my lord. It says in the event. In the event, the government is of the view that only diploma holders should have applied to a post of sub-engineers, but not all those who possess higher qualifications. Either these rules should have excluded in respect of candidates who possesses higher qualifications, or the position should have been made clear that degree holders should not be eligible to apply for such posts. My lord, in us there is no provision as such that this person is from a so and so. When the provision is not clear, but on the other hand, rules do not disqualify per se the holders of higher qualifications in the same faculty, it becomes clear that the rules could be understood in an appropriate manner as stated above. In that view of the matter, the order of the High Court cannot be sustained. So, my lord, unless the rule specifically excludes the respondent, private respondents, my lord, the law cannot be interpreted in such a way, my lord, that they should be excluded. And my lord, let me revert your lordship to one other point which my learned friend had already raised, but let me also point it out, my lord, because there are some petitioners. My lord, petitioner number 1 to 7. My lord, the petitioner number 1 to 7, they did not qualify after the first exam. They failed in the first exam. Petitioners 1 to 7, 9 to 19, my lord, they failed in the first round of exams. 1 to 7, 9 to 19. Petitioner number 8, my lord, somehow she passed that exam, the first exam. Petitioner number 8. Now, petitioner number 8 was found eligible along with the rest of the private respondents. She was found eligible for interviews. Petitioner number 8. She participated in the interview also, my lord, petitioner number 8. And after she was disqualified in the interview, after she failed in the interview, my lord, she has come before this court along with the rest of the petitioners. My lord, this is something we have to point out. Your lordship had raised that point about blowing hot and cold. Even if the rest of the petitioners cannot be applied, my lord, at least petitioner number 8, my lord, cannot come to this court after she has participated in the interview. That is one point I would like to stress, my lord. I don't have to go into that law again because she knows it. And my lord, with respect to the rest of the petitioners, my lord, at page 84 of the writ petition, if your lordship will see page 84,
Yes.
this was the first list of candidates who were shortlisted, my lord. And in this, the names of the private respondents are also reflected.
Yes.
However, the petitioner number 1 to 7 and 9 to 19, my lord, their names are not reflected in this. This is the list of successful candidates.
Yes.
They have not challenged this. This notification was never challenged by them, my lord.
No, on what ground they could have challenged it?
They could have challenged it on the same ground.
That was not known to them.
Till today, they have not challenged it in this writ petition.
No, that ground was known to them only in the month of June.
In the month of June, my lord, they know it today also. They will know it next year also, but today also they have not challenged it in this writ petition. In their prayer, my lord, this has never been impugned. In fact, lordship, at page number 84,
Yes.
this is the list of provisionally accepted and the rejected list. In this, many of the petitioners' names were reflected as accepted list, accepted, my lord. This also has never been challenged in the writ petition, my lord. If your lordship will see the prayer in the writ petition. In other words, my lord, they have no right.
Yes.
In other words, my lord, this is my submission. The first notification, my lord, which specifically points out those who are successful, implicitly also highlight those who are not successful. They are the ones who are not successful, my lord. Now they have not challenged that in their writ petition, my lord. That is what I'm trying to say. They should have challenged this notification also. If your lordship will see page number 17 of their writ petition, my lord.
Okay. What they have challenged?
My lord, they have
They have
challenged
challenged the final
annexure number
recommendation.
8. This is notification dated 8/7/2025.
Final recommendation.
Correct. No, they have challenged notification dated 8/7/2025, which is at page number 101. They have also challenged notification dated 10/7/2025, which is at page number 107. And finally, they have challenged notification dated 30/7/2025. But the first one, my lord, which points out, which implicitly shows that, which implicitly declares that they were not qualified, my lord, has not been challenged. They need to challenge, my lord. Otherwise, this writ petition is without any legs. They have no rights. They are not claiming for recruitment also. They are not claiming for appointment because they don't have right to the appointment. They are not in the panel list also. In fact, my lord, my learned friend had raised about the rest of the community, some BE graduates who would also want to participate. My lord, if those people wanted to participate, they can file a writ petition, but none of them are filing. They are all silent, my lord. They have challenged it only after they were unsuccessful, and that too they have not challenged the notification in which they were rejected.
Now, what else is their prayer?
My lord, their prayer is
They have sought for themselves?
my lord, they have not sought anything for themselves. If your lordship will see the prayer, I will read the last few parts, my lord. I'll read from the beginning itself. In the premises, from page 17, my lord. It is most humbly prayed that your lordships may graciously be pleased to admit this petition. Call for the records and issue rule calling upon the respondents to show cause as to why the impugned notification dated 8/7/2025, declaring the final accepted list and final rejected list of the candidates. 2. The impugned notification memo dated 10/7/2025, declaring the results of the written competitive examination of the post of surveyor and the candidates qualified for personal interview, and the impugned notification memo dated 30/7/2025. Now, my lord, the petitioner number 8 is also challenging her own qualification, the notification which she was accepted. To the extent the impugned notification dated so and so, declared and recommend the respondents number 6 to 7 for appointment to the post of surveyor under the Land Revenue and Settlement Department, Government of Mizoram, shall not be set aside and quashed, and after hearing the parties be further pleased to make the rule absolute and direct the respondent numbers 1 to 5 to restructure the final accepted list of candidates and the recommended list for appointment to the post of surveyor under the Land Revenue and Settlement Department, Government of Mizoram, by removing the respondents number 6 to 7, along with all other such eligible candidates not having completed at least 1 year survey course from any government recognized institution, and to pass any order as their lordships may deem fit and proper. My lord, they have not claimed anything for themselves. Finally, my lord, one last judgment, my lord, that I will cite, my lord. This is reported in 2008, Volume 4, SEC 171, my lord. 2008, Volume 4, SEC 171, page number 171. My lord, this is a short judgment. My lord, I will read only from paragraph 1 to paragraph 10. My lord, it's very short judgment. It's only like, these paragraphs are very small, my lord. I'll start, my lord. I'll start from paragraph 3, my lord. Special leave petition number 1466 of 2743 of 2006 have been filed by the selected candidates. The High Court, by the impugned order, set aside the entire selection and appointments of assistant teachers physical education in Garhwal Mandal. According to the High Court, the selection and appointments were made in violation of the rules. By an interim order dated 27/1/2006, this court stayed the operation of the order of the High Court, and therefore they are still holding the post for which they have been selected. An advertisement was issued on 24/6/2002 for Garhwal region for the selection and appointment of the physical education teachers, LT grade. The requisite qualification indicated in the advertisement is BPE or graduate with diploma in physical education. The unsuccessful candidates in the interview challenged the selected candidates on various grounds. One of the grounds was that the advertisement and selection were not based in accordance with the rules called the UP Subordinate Education Trained Graduate Grade Services Rules 1983. We will examine the rules a little later. The unsuccessful writ petitions were dismissed by the single judge. On appeal by the unsuccessful candidates, the order of the single judge was reversed and the appeals was allowed. Hence, these appeals by special leave, we have heard the parties. 6. Before we proceed further, we may point out at this stage that the writ petitions were rightly dismissed by the single judge and the division bench of the High Court fell in error in entertaining the appeals. It is not disputed that the respondent writ petitioners herein participated in the process of selection, knowing fully well that the education qualification was clearly indicated in the advertisement itself as BPE or graduate and diploma in physical education. Having unsuccessfully participated in the process of selection without any demur, they are stopped from challenging the selection criteria inter alia that the advertisement and selection with regard to requisite educational qualifications were contrary to the rules. In Madan Lal versus State of Jammu and Kashmir, this court pointed out that when the petitioners appeared at the oral interview conducted by the members concerned of the commission who interviewed the petitioners as well as the contesting respondents concerned, the petitioners took a chance to get themselves selected at the said oral interview. Therefore, only because they did not find themselves to have emerged successful as a result of their combined performance both the written test and the oral interview, they have filed a writ petition. This court further pointed out that if a candidate takes a calculated chance and appears at the interview, then only because the results of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted. In the present case, as already pointed out, the respondent writ petitioners herein participated in the selection process without any demur. They are stopped from complaining that the selection process was not in accordance with the rules. If they think that the advertisement and selection process were not in accordance with the rules, they could have challenged the advertisement and selection process without participating in the selection process. This has not been done. In a recent judgment in Miripati Nagaraja versus Government of AP, SCR at so-and-so, this court has succinctly held that the appellants had appeared at the examination without any demur. They did not question the validity of fixing the said date before the appropriate authority. They are therefore stopped and precluded from questioning the selection process. My lord, this much, my lord, I'll read. My lord, my humble submission is the advertisement and the rules clearly lays out the requirements, my lord. It does not say it has to be separate. The DPNAR made the interpretation. Whether they know the DPNR interpretation is one thing, but the advertisement and the rules are clear enough, my lord. They should have not participated if they were not happy with the advertisement, my lord. This is my submission. And the course, my lord, they are strikingly similar also. Let me point out, my lord. Even though the courses, these two courses, my lord, sorry, if your lordship will see our affidavit affidavit in opposition, my lord, at page 56. Now, my lord, broadly everything has been mentioned, so we cannot go into the specifics and say these two are not the same, it's not identical and all of that, but if your lordship will see the syllabus also, this is 56, is the syllabus, page 56. So, my lord, annexure 3, page 56 is the syllabus given by the MPSC, from the MPSC website.
For the surveyor.
Correct, my lord. And my lord, I will only take your lordship to the syllabus outline of the Mizoram University. I will not go to every university. At page 64 of the same affidavit, my lord, is the Mizoram University survey course outline. My lord, these are only outlines, my lord. They don't provide the specific of everything. Now at page 64.
Yes.
Now, my lord will see unit 1, introduction and chain surveying. Introduction and chain surveying. Now, if your lordship will turn to page 56, your lordship will see paper 3. It says introduction of surveying. Paper 3, introduction of surveying. Then second, my lord, your lordship will see second, it says chain surveying. Chain surveying. Which means introduction and chain surveying, my lord, are more or less the same. Then your lordship will see unit 2 from page 64. It says like this: compass surveying and plane table surveying. Now in the MPSC syllabus at number 3 it is compass surveying, and number 4 plane table surveying. Again same course. Then number 4 from page 64.
In engineering course, the surveying course is for how many?
1 year, 2 semesters, my lord.
2 semesters. Where is the indication?
My lord, Unit 1 and Unit 2, my lord, this is how I have been instructed. My lord, Unit 1 and Unit 2 are those they had learned in the first semester, in 1 semester. Unit 3, Unit 4 and Unit 5 are learned in the second part of the semester. My lord, let me see. Let's see. Sorry, my lord, your lordship will see, this is surveying 1, Unit 1. Unit 1, the entire thing I have shown till this page 65 is Unit 1 is surveying 1. Then surveying 2, this is the second. Surveying 2 has several courses in surveying 2. Everything is there, my lord.
Okay.
I mean, we can go one by one, we can file an affidavit comparing these two, my lord, but I don't think that is required. MPSC has already done the comparison and they were satisfied.
Okay.
So, my lord, these are my submission, my lord, at this stage.
Any reply?
If I can give a short reply, Your Worship.
Yes.
I'll give a reply to the submission made by the private respondents council first, Your Worship. And I think it's general to all of them. The stand taken by them is that after appearing the selection process, the petitioners could have challenged the result of the selection process.
Yes.
In regard to that, I would like to rely on uh, 2020 Volume 4 SCC, page 86. Volume 4, SCC, page 86, relevant paras is 77 and 78. At para 77, you should at page 116.
Yes.
Shri Dave, placing reliance on Ashok Kumar versus State of Bihar, contends that the candidates who have participated in the process could not have been allowed to challenge the selection. And they have referred to a number of judgments of the Supreme Court. I'll take your lordship directly to para 78, page 180. Lordship, para 78. The present is a case where the writ petitioners were not aggrieved by any qualifications as prescribed in the advertisement. The cause of action had arisen to them to seek judicial review only when the persons who did not fulfill the essential qualifications were included in the select list.
This is your case. Okay.
Another judgment is Volume 8 SCC 713. Well, 2022 Volume 8 SCC 713, paragraph 2324. Relevant page is page 720. Para 23, page 720.
Yes.
However, the division bench fell in error in applying the principle that the appellants having appeared in the interview and being unsuccessful proceeded to challenge the same, and on that ground alone allowed the appeals, set aside the judgment of the learned single judge. The division bench, having approved the reasoning of the learned single judge, ought not to have interfered in the judgment of the learned single judge on a technical plea. The division bench ought to have considered that the appellants were Class 4 employees working from 1977 onwards and expecting from them to have raised serious objection or protest at the stage of interview and understanding the principle of changing the rules of the game was too far-fetched, unreasonable and unwanted. Para 24 is relevant, Your Worship. The case laws relied upon by the division bench would have no application in the facts of the present case, as none of the judgments relied upon by the division bench laid down that principle of estoppel would be above law. It is settled principle that principle of estoppel cannot override the law. So even in this case, the rules is very specific, it is very clear. There has to be a graduate with at least 1 year survey course from a government recognized institution. The rules are very clear. And the principle of estoppel cannot override the law. We are challenging the interpretation of the law made by the respondents. They have allowed the private respondents who do not have that qualification of 1 year survey course from a government recognized institution to participate in the selection.
No, their submission is that the 1 year survey course is included in their BE degree course.
It is included. Assuming it is included, but then what does the rules require, Your Lordship? The rules requires graduation plus 1 year, at least 1 year survey course from a government recognized institution. It is twofold. But then, if that was the case, Your Worship, the state government could have easily amended the rules by saying that, okay, since the BE civil graduates have this 1 year survey course in their curriculum, it is not required for them. The rules were never amended, and this clarification was never given publicity also. So many other graduates, BE civil graduates, could have also applied. But because it was not given publicity, there was no corrigendum, many have failed to apply. If the intention of the government was such that BE graduate civil who have completed 1 year's course of surveying during their curriculum, they can be allowed to appear.
No, suppose they are disqualified.
Yes.
Then would you be selected by
No,
that?
they have to restructure the whole select list only from those candidates who have the requisite qualifications. And by then we can, our number can go up. As long as those unqualified candidates are shunted out and the select list is restructured, we have every chance of being selected. Sorry, 2019, volume 20 SCC.
On what point?
Again, selection process, S4.
Estopel, you have already,
Just one last.
which one should I rely?
I mean, all the three judgments, Your Worship, are making it much clearer. Just one thing from this principle, insofar as the candidate, by agreeing to participate in the selection process, only accepts the prescribed procedure and not the illegality in it. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequences arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provisions of the Constitution unless he/she participates in the selection process. And my learned friend had relied, the learned counsel for the private respondents, Your Worship, had relied on a number of Supreme Court judgments regarding interpretation of statutes. And it is very clear that when the rules are clear and there's no ambiguity in it, it has to be applied according to his own judgments. Even in our case, the rules are very clear and the intention has to be gathered from the rules. The rules clearly say that it has to be a graduate plus at least 1 year survey course from a recognized government institution. So there is no ambiguity. If we just read the rules as it is clear that the private respondents have not fulfilled the criteria at all. And if your Lordship will see, we have challenged in the writ petition, we have challenged annexures 8, 9 and 10. Annexure 8 we have challenged annexure 8, 9 and 10. And before that, they had, if your Lordship will see annexure 6, they had issued the provisionally accepted list and provisionally rejected this. Page 90 of the writ petition.
Yes.
And there, it was clearly stated that any objection with regard to the publication of the list shall be submitted in writing. At page 90, the English translation, Your Honor.
Yes.
It is very clear that any objection with regard to the publication of this list shall be submitted in writing to the undersigned within 1 week. They shall submit a letter of complaint, clearly stating their complaint. That, Your Worship, we had submitted our representations to the respondent number 4 and 5. At para 10 of the writ petition, we have clearly stated that petitioners number 1, 11, 15 and 17, being aggrieved by this notification dated 4th June 2025, had submitted separate representations against this provisionally accepted list. But we did not get any reply from the NPSC. Although we submitted representations as per this notification, the petitioners number 1, 11, 15 and 17, we did not receive any reply from the Commission. And then after that, they had published the final accepted list on 8th of July 2025, after which the results were declared on 10th of July 2025. And subsequently, the recommended list was issued on 30th of July 2025. And we had filed the writ petition in August. And on 14th of August, stay order was granted by this Honorable Court. So where's the delay here? Straight away, they issued the provisional list. We submitted our representations. No answer. They issued the final accepted list, then the final recommended list, and straight away we submitted the writ petition before the appointment orders were issued.
Anything else?
Yes, Your Honor. Your Honor, the state government, in para 9 of the affidavit, my learned friend had also read out para 9 of the affidavit filed by the state. Para 9.
Yes.
The reason given by the state respondents for allowing the graduate engineers to take part in the selection process is that surveyors, in the middle of the page, right? Surveyors were initially recruited in the past years from qualification of metric, class 10 pass, having 1 year diploma in survey training, who were found rather incompetent and having limited ability to perform departmental works and duties requiring English writings and speaking. And now, this is not the case of the respondents that the petitioners are matriculates. As per the recruitment rules, prevailing recruitment rules, it is graduates who are eligible with 1 year survey course. And we are all graduates. We have submitted all the certificates required for applying along with the writ petition. It is not the case of the respondent that since we are matriculates, we will be incompetent. So my learned friend is, I think, going back in time when before the rules were amended by saying that matriculates are not fit enough to do the work. But the rules clearly says that It is the graduates. And para 17 of the writ petition, Your Worship, regarding the clarification having not been issued for the public and no corrigendum was issued. This point was taken by us in our pleadings at paragraph 17. It was a specific stand taken by us in the pleadings. It is not that we have not pleaded the said point in our pleadings. In para 17, we had clearly taken up that ground. And my learned friend, appearing for respondents number 4 and 5, had said that it is for the employer to decide the qualification. And the honorable courts do not have the power of review. And Your Worship, my humble submission is that yes, it is the employer, it is the respondents number 1 to 3 who have decided the qualification as per the recruitment rules. They have to abide by it. They cannot violate their own rules. And my learned friend had also submitted that the advertisement does not mention that it has that diploma has to be 1 year course from a government recognized institution. He had pointed out that there is a slight difference in the advertisement and the recruitment rules. The advertisement is at page 65 of the writ petition. They had said that the advertisement talks only about bachelor's degree who have completed 1 year survey course. It does not mention that it has to be from any government recognized institution, which is as per the rules. With regard to that, Your Worship, I'd like to take your lordship to 2022 volume 11 SCC 392. 2022 volume 11 SCC 392.
Yes.
I'll read para 20 at page 406.
Yes.
Para 20, if I may. The advertisements issued by the applicant mentioned that the DACP scheme would be applicable for its recruits. However, it is a settled principle of service jurisprudence that in the event of a conflict between a statement in an advertisement and service regulations, the latter should prevail. In Malik Mazhar Sultan versus UP Public Service Commission, a 2-judge bench of this court clarified that an erroneous advertisement would not create a right in favor of the applicants who acts on such representation. So, if there is a slight conflict between the advertisement and the rules will prevail. Para 21 also. In Ashish Kumar versus State of UP, a 2-judge bench of this court followed the decision in Malik Mazhar Sultan in interpreting an advertisement issued by Director Soil Welfare Department, Uttar Pradesh, for the position of a psychologist. This court declined to give precedence to the erroneous qualifications prescribed in the advertisement against the relevant recruitment rules and held any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Thus, looking to the qualification prescribed in the statutory rules, the appellant fulfills the qualification and after being selected for the post, denying appointment to him is arbitrarily illegal. It is well settled that when there's variance in the advertisement in the statutory rules, it is the statutory rules which take precedence. So trying to take advantage of the wording in the advertisement is futile because it is the rules which will prevail over the advertisement. Just because the advertisement has missed out that it should be from a government recognized institution, they cannot take advantage of that. And lastly, since the clarification was not given publicity, no corrigendum was issued, even the corrigendum has no legs to stand, and the clarification has no legs to stand.
Heard Mr. A.R. Malhotra, learned counsel for the petitioner. Also heard Ms. Linda L. Farmwell, learned additional AG, appearing for respondent number 1, 2, 3. Mr. J.C. Lalnang Sangha, appearing for respondent number 4 and 5. And Mr. Joseph L. Renthley, appearing for respondent number 6 to 17. Hearing concluded, judgment reserved.